Good morning, everyone. Welcome back. Before we start, I know we've got we celebrated Veterans Day yesterday, and all the state offices are closed mostly for Veterans Day. But I would like to stop just for a moment of silence for those veterans who we honored that lost their lives over the years, and honored for their service still happening. So everybody will join me in that moment of silence. Thank you. Okay, I'm going to turn it over first to Mr. Butler. Oh, before I do, we still got a really nice charger somebody left up here last week. Gonna look good in my office after another couple of days. Yeah. Mr. Butler.
Yes, sir. Thank you, Mr. Chairman. Good morning to you. Just wanted to do a few housekeeping things. In looking at our calendar, I think we're getting through the pre-file pretty well. Wanted to basically say that we're really going to need the proposed orders in this matter by the 7th of December at the latest in order for the commission to do its work at this end. And I'm hoping you will keep this in mind as we go forward with the rest of this case and try not to prolong things any longer than necessary. I do note that at present we have a fairly lengthy list of possible non-pre-file and deposition witnesses. I would appreciate it if the parties would take another look at that for us. There may be some that you may feel aren't necessary after the things that have come out with cross-examination and the presentation of the pre-file witnesses. They may be able to be pared down some. It looks like we will have the week after Thanksgiving to do mostly the non-pre-filed and deposition material, but hopefully some of that can be pared down. So if the parties will at least discuss paring down those non-pre-file and deposition lists, it would be most helpful. But, once again, just be aware we are going to need, no matter what, we're going to need those orders, those proposed orders by the 7th of December. And that would be extremely necessary for us to get our work here at the commission done. Another couple of things, I would say when you do file the proposed orders with the commission and serve them on the parties, please do send me a Word version as well as filing with the commission and serving. Please send me a Word version by email. It would be most helpful. Also, we have had some indication that there may be some parties who will want to present clips of video depositions at some point during these proceedings later. And I would say to you, if that is your plan, and if indeed that does occur, what we will need you to do is provide clips of those videos to Ms. Wheat for proper inclusion in the transcript in this case. And it would be much easier if you do present video clips to Ms. Wheat, and that will expedite matters in that department. But again, I think we're doing fairly well on the pre-file witnesses, but always, we really need to be expediting this case so as to meet our goals in the matter. Thank you very much, Mr. Chairman.
Thank you. Just as another reminder, just wanted everybody to remember to coordinate your cross, keep it short. Remember how you can compress things, and because by the time we get to Thanksgiving, we've been having nice little 4:30 endings, but we can go a long time. I've already seen the B-52, so I don't have to worry about leaving early for that. So we'll be moving along. All right, so here we are. Today, I think we have some date certain folks. So, Ms. Medlin from DOD, hang on, one preliminary.
Mr. Chairman, I'm Chad Burgess for SC&G. Just one administrative matter. On Friday, Mr. Elliott was inquiring of Mr. Addison with respect to who's going to pay for legal expenses incurred by the company, shareholders, or ratepayers. We've researched that issue over the weekend, and the shareholders are going to pay the legal expenses of the company. So I think that no longer requires a late filed exhibit. I talked to Mr. Elliott about that before the hearing started, so we believe that issue's been resolved.
Okay. Hit that microphone.
That explanation satisfies my
Okay.
inquiry, Mr. Chairman.
Okay. Thank you. Thank you. Thank you. Yes, sir.
Mr. Chairman, Mitchell Willoughby for SC&G. One additional administrative issue. I need to hire your court reporter, Joe Wheat, as an assistant lawyer for me, because she points out that when I tendered the documents for Mr. Hebert and Ms. Lapson on Friday, there is an Appendix A to their direct responsive testimony that was filed on September the 24th. It was my intent that all of the exhibits attached to that testimony, as well as the Appendix A, be included and copied into the record of docket number 207 and 305 as well. And as it turned, that testimony was already adopted, and so it's really just a filing issue. So I want the record to be clear that Hebert and Lapson's Appendix A attached to their direct responsive testimony filed on September the 24th is in the record in those dockets, as well as the other information that was incorporated into the record on Friday.
Okay, that's good. That's fine.
Thank you very much,
Okay,
Mr. Chair.
we've got it. Anything else preliminary? All right.
Good morning, Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies. And thank you, Mr. Chairman, for the moment of silence. It's appreciated. I'm going to call Mr. James Selecki to the stand.
Mr. Selecki, hang on one second. We just want to remind everybody to talk into that microphone so you can be picked up by the live stream.
Yes, sir.
Thank you.
Mr. Selecki, could you please state your full name for the record?
My name is James T. Selecki.
Where are you employed and what is your position?
I'm employed at Brubaker & Associates, Inc., an energy consulting firm based in St. Louis, and my position there is I'm a principal with the firm.
Mr. Selecki, did you prepare direct testimony along with Attachment A dated September 24th, 2018, which was pre-filed with the Commission in docket number 2017-370-E?
Yes, that's correct. It was Appendix A.
Appendix A.
I labeled it, yes.
Do you have any changes or additions to your pre-filed direct testimony?
I have none.
If I asked you all the questions contained in your pre-filed direct testimony along with Appendix A here today, would your answers be the same?
Yes, they would.
Mr. Chairman, I move that the pre-filed direct testimony along with Appendix A of James T. Selecki in docket 2017-370-E be admitted into the record as if given orally from the stand.
Mr. Selecki's pre-filed direct testimony and appendix will be entered into the record as though given orally from the stand.
Mr. Selecki, have you also submitted two exhibits labeled JTS-1 and JTS-2 with your pre-filed direct testimony?
Yes, I have.
Do you have any changes or additions to those exhibits?
I do not have any changes or additions.
Mr. Chairman, I move as the next composite hearing exhibit JTS-1 and JTS-2 that are attached to Mr. Selecki's pre-filed direct testimony in docket number 2017-370-E.
Mr. Selecki's exhibits JTS 1 and 2 will be entered as hearing exhibit number 80.
Mr. Selecki, have you prepared a summary of your direct testimony?
Yes, I have.
Okay, and I've already given handouts out to the commission, but I'll give these out to the parties real quickly. Mr. Selecki, would you please give a summary of your direct testimony?
Yes. My name is James Selecki, and I'm appearing on behalf of the United States Department of Defense and all other federal executive agencies. My testimony addresses just certain aspects of the proposed merger between SCANA Corporation, SCANA, and Dominion Energy Incorporated, Dominion Energy. I'm not taking any position as to the appropriateness of the merger between SCANA and Dominion Energy. I'm only addressing provisions of their proposed customer benefit plan. Specifically, my testimony addresses the treatment of the proposed one-time credit of $1.3 billion, the use of securitization to recover any project costs that the Public Service Commission of South Carolina may authorize for recovery from South Carolina Electric and Gas Company ratepayers, and the federal income tax rate used in the development of the revenue requirement for the amortization of approximately $3.3 billion of new nuclear development costs. One of the requirements of the customer benefit plan is an upfront one-time rate credit totaling $1.3 billion for SCE&G electric customers. This one-time credit will be issued to customers in the form of a check. I am proposing that SCE&G customers should have the option of either receiving that amount in a check or a credit on their electric bill. The DoD/FEA customers will not benefit specifically from a one-time credit if it is issued as a check. Any check that the DoD/FEA customers receive as a result of the merger will be turned over to the United States Treasury. As such, these customers will not benefit specifically or see any direct reduction in their utility costs, despite the fact that these customers paid for the NND project costs over years in their rates. As a result, I am proposing that eligible customers have the option as to how they will receive any one-time credit that could be authorized in this proceeding. These customers should be allowed to choose between a bill credit or a one-time cash credit. Dominion Energy is proposing to amortize $3.3 billion of NND project costs over a 20-year period, and that amortization will be afforded what I refer to as traditional rate-making treatment. That is, a portion of the NND project costs that have not been recovered from ratepayers will be subject to SCE&G's pre-tax cost of capital. The pre-tax cost of capital that will be applied to the unamortized balance of the NND project will be 9.97%, assuming the 21% federal tax rate. I recommend that any NND project costs that the Commission authorizes to be recovered should be securitized. The revenue requirement associated with securitized assets is substantially less than the revenue requirement assuming a traditional pre-tax rate of return. Securitization could reduce cost to ratepayers by hundreds of millions of dollars. The reason securitization provides a lower cost is that under securitization, the cost of capital is simply the cost of AAA-rated bonds plus any issuance costs as opposed to the pre-tax cost of capital. This would reduce the carrying costs and the unamortized balance from the 4 to 5% range to the 4 to 5% range from 9.97%. I am aware that there is no legislation in place in South Carolina that supports securitization. However, given the significant savings that securitization can provide, efforts should be made to secure the necessary legislation to allow securitization to occur. It appears that securitization would provide a viable economic alternative, and that alternative should be pursued because it can provide substantial benefits to the ratepayers. Finally, if the securitization of the NND project is not feasible, the current federal income tax rate of 21% should be used to develop any NND project costs that are included in rates. A 35% federal income tax rate was utilized by Dominion Energy and SCANA to develop the annual revenue requirements associated with the amortization of the NND project costs. The Tax Cuts and Job Acts of 2017 lowered the federal tax rate to 21%. To reflect the lowering of the federal tax rate, Dominion Energy is proposing to implement an NND tax rider. The NND tax rider reduces the amortization costs to be recovered to reflect the lowering of the federal tax rate from 35% to 21%. I recommend that the current federal income tax rate of 21% be used to develop all the revenue requirement and the rates associated with the recovery of NND project costs, and that will result in the elimination of the NND tax rider. This will simplify further regulatory requirements by not having to adjust rates annually to true up for federal income tax component associated with the amortization revenue requirement of the NND costs. That concludes my statements.
Thank you. Mr. Selecki is available for cross-examination.
Thank you. Okay, Mr. Guile.
Thank you, Mr. Chairman. Mr. Selecki, thank you for your testimony. I have no questions.
Other cross. Other parties. Company.
Mr. Selecki, thank you, Mr. Chairman, members of the Commission. Mr. Selecki, my name is Mitchell Willoughby. I represent SC. I have just a couple of questions. You've acknowledged that there is currently no legislative mechanism in place to support securitization, correct?
Yes, sir.
And without a full legislative support, securitization is simply not possible, correct?
I would agree with that.
And do you understand that the investment community would have to have total faith and trust that the South Carolina General Assembly would not change the rules of the game after they have placed securitization into effect, even if they passed securitized legislation? Do you understand that to be true?
Yes, I understand that to be true.
And so if the general investing public did not have faith in the General Assembly complying with its promise in any legislative support, and there was the potential that 5, 6, 7, 8 years, 9 years down the road, the General Assembly would change its mind as a new General Assembly came into being, would that dampen any interest by the investing community in investing in securitized products?
If the investment community viewed that there could be the potential for change in the legislation that would dampen the cost, I do not believe that's happened in any of the other states, though.
But it would be a concern that would need to be taken into account.
The financial community would look at the existing legislation and assess all the risk to determine whether securitization is a viable option.
Thank you very much. And one final question. And to the extent there's any risk involved, the only reason you get low interest rates in a securitized instrument is because people view them as being very low risk, correct?
Correct.
And if the investment community perceived there to be any risk, then the rate, even if the bonds could be placed, the rate would be potentially substantially increased.
It would be higher. I don't know what substantially means, but it would be higher if there's more risk perceived.
Thank you very much. Those are all my questions.
Yes, sir.
Thank you, Mr. Willoughby. Mr. Reed?
No questions, Mr. Chairman.
All right. Commissioners?
Mr. Chairman,
Mr. Williams?
a couple of questions for this witness. Good morning, sir.
Good morning.
You talk about securitization on page 8 of your direct testimony. I have a couple of questions regarding securitization. Obviously, they're hypothetical because there's no law on the books regarding that issue to date. But just for hypothetical purposes, would a special purpose financing entity be set up by the company or by an independent party?
It would, I guess it would, in my experience, has been set up by the company, but it would be an independent party. I mean, they would make the necessary arrangements for that to take place.
Okay. So what would happen to the special purpose entity once the bonds are paid off?
It would essentially disappear. I know in the case of Consumers Energy, they've had two securitization issues. The first one was stranded costs associated with their nuclear power plant Palisades, and that happened in around 2002, in that time frame. Then in about 2013, they retired some coal-fired units, and there was still some unamortized balance to be collected from ratepayers. The commission in Michigan utilized securitization to collect that unamortized balance. It's my memory cells tell me that in those cases, different SPEs were set up for each alternative. In fact, I think the structure was somewhat different in each instance. So I have to say that I assume that the first one was gone because that Palisades issue, the Palisades recovery of the stranded costs had already been completed.
Okay. One last question, Mr. Selecki. Could the company use the special purpose entity to refinance debt on an ongoing basis, or would a special entity have to be created each time the company's assets are securitized?
My understanding, based on, again, my reference to consumers, I think if you had separate events that caused the securitization, you'd set up separate SPEs.
Okay. Thank you for being here, sir.
You bet. Thank you.
Thank you. Commissioner Elam.
Good morning.
Good morning, sir.
Does DOD in South Carolina take service from SCEG under a tariffed rate, or do you have a contractual rate?
I think they're all tariff rates. The bills that I've seen, they're all tariff rates.
Okay. Thank you.
Thank you. Commissioners. Commissioner Urban.
Thank you, Mr. Chairman. Good morning, sir.
Good morning.
If you give customers a choice between a bill credit and a one-time payment by way of a check, doesn't that confuse the issue in the sense that all you really want your DOD to get is a credit? But if you have, let's say, 40% of the people want credits and 60% want one-time checks, isn't that going to create problems for the company in terms of allocation and, doesn't that create extra work for the company?
It could create some extra work, but I think there could be provisions created, like, in my estimation, most of the people want a check, a one-time check. But
What if they can't be located? We're talking about 3 years ago. We got people that have moved outside the state, people that have died, no forwarding address. How are you going to deal with those in terms of a check? Would the estate get the money, or nobody gets it if the ratepayer is not alive? It just seems like a cumbersome process to issue checks.
I guess it could be. I have not looked. I thought that the checks were going to be issued based on the customers that were taking service in 2016. So I think the chance of customers being gone from the state, I think that should be, far and few in between, but that could be a problem. I will tell you this, when I worked at Detroit Edison, we had a refund where we had to send everybody a check. And we had to research back who had left the system over that point in time. And it did cost back then, unfortunately that was 35 years ago. Computers then weren't what they are today. So that's what probably caused us more of the problem when I worked at Detroit Edison.
So how many of those checks came back unclaimed?
I don't remember, but I believe all the money was given back to ratepayers then, because there was a reconciliation and a true-up, if my memory serves me right.
Okay. So if they weren't cash, the money was put back in credit.
Credit, yes.
For others?
Yes, sir. That's my recollection.
Well, you'd be satisfied with a straight credit for DOD.
Yes, sir.
Thank you.
Okay.
Thank you, Commissioner Irvin. Any other commissioner questions? Okay, Ms. Medlin, any redirect? Thank you. All right, Mr. Selecki, you did well and you're excused.
Thank you, sir.
Okay, now we'll go to Mr. Kaufman with Mr. Rubin.
Morning, Commissioner. We are calling our expert witness, Scott Rubin. Would you please state your name and your position?
Scott Rubin, R-U-B-I-N. I'm an independent consultant and attorney.
And are you the same Scott J. Rubin that is caused to be filed in this case, direct responsive testimony on September 18th, and in which were attached to it 12 exhibits?
I believe there were 13 exhibits, as well as an appendix.
Oh, yes, the 10Q, yes.
But yes.
And are you also the same Scott J. Rubin that caused to be filed surrebuttal testimony in this case?
Yes.
And if I were to ask you the questions contained in these two pieces of testimony today, would your answers be the same today?
Yes, they would.
With no corrections?
Correct.
With that, Your Honor, I would offer into the evidence the direct testimony of Scott J. Rubin and the surrebuttal testimony, and ask that it be put in the record as if read orally.
Okay, Mr. Rubin's pre-filed direct testimony as well as his pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
And if necessary, I'd like to offer separately the exhibits, 13 exhibits labeled SJR 1 through SJR 13, which are attached to his direct testimony.
Okay, Mr. Rubin's exhibits SJR 1 through 13 will be entered as exhibit number 81.
Excuse me, Your Honor, what are the numbers for the direct and surrebuttal?
They've just read in, the direct is just read into the record. They're not exhibits.
Excellent, thank you. With that, I would offer Mr. Rubin, he has a summary to read. Sorry, I have copies for the party.
Good morning, Chairman Randall, Vice Chairman Elam, and Commissioners.
Let's wait just a second and
sorry.
let him get these passed out, Mr. Rubin, then we'll let her rip.
And I feel like I'm getting some feedback from the mic. Am I too close, or is that okay?
You sound okay from up here. Okay, I think we're all there. Mr. Rubin.
Thank you, Mr. Chairman. First, I wanted to thank you for the accommodation of providing a date certain for me to appear before you. That made traveling here and coordinating my appearances in some other cases much easier. And before I go into my prepared remarks, since we are celebrating Veterans Day, I thought it would be appropriate to mention that There are about 850,000 people in South Carolina age 65 and older, and about 40,000 of those are military retirees or survivors. And I'm honored to be able to help represent them today through AARP. So I should introduce myself a little bit. As you can tell from my accent, I'm not from South Carolina. I live and work in Pennsylvania, where I have my own consulting and law practice. For the past 35 years, all of the work I do has involved the public utility industries. I work as an attorney, expert witness, and research analyst for public and private sector clients throughout the United States and Canada. During my career, I have participated in more than 24 proposed utility mergers or acquisitions. Unfortunately, this is not the first time I have dealt with a utility's failed nuclear investment or a utility that has gotten itself into some financial trouble. AARP is paying me to provide testimony as an independent expert. I do not speak for AARP, only its staff and attorneys are authorized to do that. But AARP thought it was important for you to hear my analysis, opinions, and conclusions. Let me be blunt. You have a utility that bet the farm and lost. SCE&G poured $5 billion into a project and got nothing for it. By the end of this year, customers will have paid $2.2 billion for absolutely nothing, not a single watt of electricity. That's why we're here. I explained in my testimony that there were numerous signs in 2013 and early 2014 that the project should have been canceled. There were two huge stop signs. First, SCE&G's contractors were doing a horrible job. My exhibit SJR1, which I guess is part of Exhibit 81, is a 14-page summary of some of the problems written by the company's CEO in May of 2014. I encourage you to read it carefully. Second, SCE&G's partner in the project, Santee Cooper, was trying to find another utility to buy a portion of the project. They tried for months and could not find anyone who wanted even a 5% share of the project. Other utilities thought the cost was too high, the benefits were too small, and the risks were too great. One of the most difficult parts of a utility prudence case is trying to figure out what a reasonable utility would have done at the time if it had the information that your utility knew or should have known. In this case, you don't have to guess. Santee Cooper approached several other utilities in 2012 and 2013, presented their best case for owning a share of the project, and every single one of those utilities said no. Too expensive, too risky, it's not worth it. But SCE&G's management ran through these stop signs. At the end of 2013, SCE&G had about $2.3 billion invested in the project. By the time they finally canceled in July of 2017, they had more than doubled their investment to about $5 billion. SCE&G's customers already have paid $2.2 billion for nothing. There are legitimate arguments that they're entitled to a refund of some or all of that. I understand some of those issues are playing out in the courts. Other parties are arguing that customers should pay billions of dollars more. I prepared a bar chart, which is in the written materials and up on the screen, to summarize some of those proposals. My recommendation is the first column on the chart. Customers have paid $2.2 billion and should not pay a penny more. You can see that the other proposals would have customers paying a total of anywhere from $3.3 billion to $5.7 billion for a project that is absolutely worthless. I don't think that's a fair allocation of the costs of a failed project. And I should mention, just to clarify, that what I'm showing on this chart and the next one are just the costs associated with the nuclear project. They do not include the tax issues and the merger issues that are essentially the same across the various options. There are some differences, but compared to the magnitude of the nuclear costs, the differences are fairly small. The second chart I prepared shows my best take on how each proposal would divide costs among customers, investors, the contractors, and the federal government, or more accurately, federal taxpayers. The cash flow for the investment will total about $7.8 billion by the time all is said and done. Customers already paid $2.2 billion of that. Toshiba already paid a little over $1 billion. Under my proposal, federal taxpayers would pay a little over $1 billion through tax deductions the company would receive, and investors would pay about $3.5 billion. Briefly, my proposal results in investors, the people who hired the managers who made these terrible decisions, paying less than half the cost of the project. You can see that the other proposals tilt the balance in favor of investors and against consumers. The company's proposals would have customers pay almost 75% of the cost, while investors would pay only 10%. There are obviously more details in my testimony. I hope this summary has helped to put some things in perspective, and I would be happy to answer any questions that you or counsel may have. Thank you.
Your Honor, we would now tender Mr. Rubin for cross-examination.
Thank you. Mr. Gall.
Good morning, Mr. Rubin. Bob Guile, I appear before the Commission on behalf of Friends of the Earth and Sierra Club.
Good morning.
Chair, may I proceed? Mr. Rubin, you've heard the term nuclear renaissance as it applies to this phase of the exercise of new nuclear construction.
I have heard the term, yes.
I take it that, given your summary, that you just were able to join us this morning for your testimony. You did not hear the testimony of South Carolina Electric and Gas's CEO, Jimmy Addison, earlier in this proceeding?
I did not, no.
We have this live stream function, so you could have been watching it on television, but you didn't have an opportunity to hear Mr. Addison.
Not Mr. Addison. I did watch some of the proceedings, but unfortunately I had a conflict the day that he was testifying.
Well, I hope I wasn't doing anything embarrassing at that front table, but my friends have been telling me I should watch my P's and Q's. Mr. Addison gave a summary when he testified, and I just want to ask you to comment on a portion of it. At that time, page 2 of his summary, lines 18 and following, Mr. Chairman, Mr. Addison said this, speaking of the time in which the company embarked on this failed project, I quote, "The company believed it had found the best option in the new AP1000 nuclear units. The VC Summer Units 2 and 3 project was one of some 18 nuclear projects on the Nuclear Regulatory Commission's licensing list at that time. SCE&G was not alone in thinking that nuclear was the best strategy for the future, period." Close quote. Now, they may not have been alone at that time, but they're virtually alone today, with only 2 utilities of the 18 actually having embarked on construction of these units. Isn't that correct?
Yes, it is.
Now, in your opinion, or do you have an opinion as to whether the fact that SCE&G sought to go virtually alone, at least as long as it did, whether that bears on the prudence of the new nuclear development costs that actually were incurred that are before this commission for review?
Well, if you're asking me to go back to roughly 2008, I did not do any analysis looking back that far. Things in the electric industry were very different in the early 2000s than they were by 2010, 2012, that time frame. The biggest change was the very rapid development of natural gas in the shale regions in Pennsylvania, Ohio, and West Virginia. Around 2007 or 2008, shale gas production increased from about 1 billion cubic feet a year to about 5 billion cubic feet a year. And it's continued to grow very rapidly since then. I think we're up close to 20 billion cubic feet this year. And that dramatically lowered the price of natural gas and improved the reliability and availability of the natural gas supply. So utilities that in the roughly between 2000 and maybe 2010 were looking for generation options. By the time 2010 rolled along, natural gas was basically the only large-scale option on the table because the cost had come down and the supply had become much more reliable. So earlier than that, in the mid-2000s, some utilities were looking at nuclear. I think most of those that abandoned it in favor of natural gas.
Right. You mentioned in your direct testimony extensively the second, stop sign that you allude to in your summary that the company ran through was the efforts by Santee Cooper to market a portion of their 45% interest in the project. You recall that testimony?
Yes.
I think you point specifically to work done by a Santee Cooper consultant, Howard Axelrod. You remember that testimony?
I do, yes.
And Mr. Axelrod, in the 2013 timeframe, pointed to the cost competitiveness of combined cycle gas as the economic alternative to the project, correct?
Absolutely, and he was not the only one. There were many energy analysts that were pointing to combined cycle natural gas as being the much more economical option for large central station power plant.
Large is a relative term, so we have 2,200 plus megawatts of proposed additional capacity embodied in the Summer Units 2 and 3 expansion, correct?
I don't recall the exact number, but it's in that ballpark, yes.
All right, I'd ask you to accept that, subject to check. You recall Mr. Axelrod observing that in that same context, natural gas combined cycle could be more flexibly added in units as small as 300 megawatts.
Absolutely, and that's one of the big benefits to combined cycle natural gas. You don't have to install it all at once. The economies of scale are roughly the same at about 300 megawatts as they would be at 500 or 1,000 megawatts.
And do you recall that Mr. Axelrod also advised Santee Cooper management, again, in opining about the difficulty in marketing their share of the unit to any other investor-owned utility, that the output costs comparison were that he estimated that that combined cycle gas facility could produce electricity at approximately $50 a megawatt hour as compared to $100, twice as much projected for the output from the Summer Units 2 and 3.
That's correct.
Do you agree with that estimate of comparative output costs that Mr. Axelrod projected?
I did not do a specific analysis of that. I looked at what Mr. Axelrod or Dr. Axelrod projected. I also looked at some other projections done at around the same time. An investment firm they just go by the name Lazard now. It used to be a much longer name. Every year or so publishes a levelized cost of electricity from various fuel sources, and their analysis in 2013 had numbers very similar to what Dr. Axelrod was using.
Now, you didn't have the benefit of being here earlier, but others have used the same term that you used in your opening or summary, and that is that characterizing SC&G as having bet the farm on this project. By betting the farm, I had in mind the fraction of SC&G's relatively small market cap compared to other utilities that it committed to this project. Are you aware of how SC&G compared to roughly the other 18 prospective new nuclear development utilities in terms of the fraction of their farm, the fraction of their market cap they were committing to a single project?
I don't know off the top of my head who all of those other 18 companies were. I know who some of them were, and they were much larger than SCE&G. I believe SCE&G was one of the smaller utilities in that original group.
What bearing, if any, does the relative fraction of its market cap compared to the amount of money investing in this single project, what if any bearing does that have on the prudence of the decision to choose this costly new project?
I don't think I can answer that in the abstract. Certainly the larger the project would be as a proportion of the total company's capitalization, the more certain you better be about the reasonableness of the investment, and the more careful you should be on an ongoing basis, because the financial health of the company really does hinge on making smart decisions every step of the way. But that's about as far as I can go in with a general question like that.
Can we agree in general that if you really are betting a larger fraction of the value of your farm, the consequences of a bad bet are more dire for the utility?
Absolutely, yes.
I notice in your background that you explain in your actual pre-filed direct testimony, Mr. Rubin, you come from the land that has had some experience with failed nuclear. Pennsylvania?
Yes, that's true. We have had our share of problems with the nuclear industry, and I started my career dealing with several of those issues, both nuclear plants that were completed, those that were canceled, and also 3 Mile Island Unit 2, which started and then, as we all know, failed within a few months after its initial operation.
I'm reading, ironically, a biography of Admiral Hyman Rickover, the father of the nuclear navy and nuclear power, and I read that he was responsible and his crew for designing the Shippingsport reactor in Pennsylvania, the first commercial nuclear power plant. Are you familiar with that?
That was before my time, but I'm very familiar with the fact that plant was the first commercial nuclear plant in the country, and that Admiral Rickover and his team were responsible for that and what they hoped would be the commercialization of nuclear energy.
With a big assist from the U.S. taxpayers. I believe the Admiral Rickover's Navy program helped design that facility. Isn't that right?
I don't know that.
All right. Now, in addition to the 3 Mile Island facility in your backyard, there's also been earlier talk before you came to visit us of reference to a notable Supreme Court decision involving the Duquesne Power and Light Company and the treatment of abandoned nuclear project costs. You familiar generally with that case?
Yes, I mentioned that in my direct testimony.
And I believe you also had some involvement in your past as in the regulatory sphere in Pennsylvania with regard to that project and others. Tell us a little bit. Remind the commission what your background was in Pennsylvania regulation.
Well, all right. This is kind of ancient history, but actually almost 35 years ago to the day, it was right before Thanksgiving in 1983. I started working for the Pennsylvania Office of Consumer Advocate, which represents the consumer interest in utility matters. And from 1983 until early 1994, that's where I worked. And I'd say a majority of my time was spent on cases involving nuclear power plants. Either new plants that were coming into service, and there were issues of prudency and excess capacity, and used and useful, and all those things. I feel like I'm having flashbacks here in some ways, as well as cases involving the prudence of continuing construction of plants that were under construction but seeing dramatic increases in cost and long delays, similar to what SCE&G was experiencing here. Some of those cases also dealt with the potential recovery of canceled plant costs. At one point, I think there were more than a dozen nuclear power plants planned in Pennsylvania, and many of those plans were canceled in the years after the 3 Mile Island accident. So that's very generally how I spent much of my 10 years with that office. During that time, the case that eventually landed in the U.S. Supreme Court was making its way through the process. The case is Duquesne Light Company versus Barish. David Barish was my boss. He was the consumer advocate of Pennsylvania at the time. And while I didn't work on the appeal, somebody had to do the rest of the work while there was a group of 3 or 4 lawyers that were spending most of their time getting ready for the Supreme Court. The rest of us were trying to keep the rest of the cases going. But we were all very much aware of what the issues were in that case and what the arguments would be and all of that. Yeah, and then we took about half an hour and celebrated when the Supreme Court's decision came out, and then it was back to work. So yeah, I don't know if you had wanted anything more specific about that, but when I was young and my beard was red instead of what it is now, that's how I spent most of my time.
Right. And that Duquesne case, Barish, resulted in a decision by the U.S. Supreme Court affirming the position of the Pennsylvania Commission, correct?
Yes, that's correct.
Well, you and I both share being long in the tooth and having been around during those early years, and I very much appreciate you offering your experience and expertise for the Commission and the rest of us here today. That's all I have, Mr. Chairman. Thank you, Mr. Rubin.
Thank you, Mr. Guile. Other cross.
Just a few questions, Mr. Chairman. Good morning, Mr. Rubin. My name is Andrew Bateman. I represent the Office of Regulatory Staff. And I have just a few questions for you. Mr. Rubin, in your testimony, you discuss a zone of reasonableness. Could you briefly describe what you mean by that?
Yes. One of the fundamental concepts of utility regulation is that the regulator is to protect consumers who the market cannot protect because the utility is a natural monopoly. So to protect consumers, rates are supposed to be just and reasonable. And obviously those are very fuzzy words, and commissions and courts and legislatures try to tell us what that means. But generally it means that rates should be somewhat comparable to what consumers hypothetically would pay if they were served in a competitive market. And at the same time, because we place an obligation to serve on the utility, as well as many other obligations, regulators are also supposed to try to protect utility investors by providing them with a reasonable return on their investment. Again, there's that word reasonable again. We don't really know what it means, but over the years there's been a lot of interpretation of that. And the zone of reasonableness is that area where just and reasonable rates overlap with providing a reasonable return to investors on their investment that was prudent and is used and useful in serving the public. There's no one right answer. There can be a whole range of answers. I spared you in this testimony, but in other testimony I've presented it as a Venn diagram and all of that. But the point is a fairly simple concept that there is a range of outcomes where consumers and investors both feel protected. And that's where, in my 35 years, almost every case has resulted in rates within that zone of reasonableness. Every now and then you get the unusual case where either rates have to be so high to compensate investors, or the quality of service or the level of imprudence is so poor that investors cannot be fairly compensated. And then you have rates falling outside of that overlap between the consumer and investor interests. But generally, we try to come up with an outcome that is protective of consumers and protective of investors.
Thank you, Mr. Rubin. And am I correct in assuming or thinking that a result which falls in this zone of reasonableness would yield just and reasonable rates for customers?
By definition, yes.
And have you had a chance to review the plans put forth by parties in this proceeding?
Yes, I have.
I'm putting on the Elmo an excerpt from ORS witness Colin's testimony.
Yes, I can.
Are you familiar with this table?
Yes.
Thank you. Mr. Rubin, does the experimental rate, which is not represented on this table, which allows for less recovery of N&D costs than does the ORS plan, does that fall within the zone of reasonableness?
Boy, that's a good question. I think the answer to that is no. But I haven't specifically tried to analyze that. And the reason I say no is what I summarized in my opening. Customers, because of the rates that preceded the experimental rate, as well as the experimental rate, have already paid $2.2 billion and received nothing for it. The bargain was supposed to be that customers would pay that money up front, and then at the back end, they would get a functioning nuclear power plant that would provide them with lower cost energy. So it was really taking a long-term view and saying, yeah, there's going to be some pain up front. You're going to advance the company a lot of money, but then you'll get lower rates for 20, 30, 40 years into the future. What happened was customers paid that money up front. They essentially invested in the company, and they never got the investment that they were supposed to get, or the benefit they were supposed to get that functioning nuclear power plant at the end. And the experimental rate is, has customers paying and continuing to pay, but receiving nothing for it. And I don't think that's within the zone of reasonableness. I haven't tried to verify it, but I've seen a couple of studies that show that residential electric bills in South Carolina are the highest in the country, which is pretty shocking given the history of electric rates in this state, which are, well, for many years were among the lowest in the country, and then they moved up somewhat. But to have customers here paying more for electricity than consumers in some very high-cost areas as far as electricity production, California, Hawaii, and some major urban centers where all the power has to be imported, is pretty shocking. So I think there's, at least in my mind, a pretty strong argument that the existing rates, which include the experimental rate, are getting awfully close to being unjust and unreasonable. And certainly now that we know the plant will never be finished and consumers will never receive anything for it, I think it's unreasonable to require customers to continue paying for it.
And does the Dominion proposed customer benefits plan, which allows recovery of about $125 million levelized for N&D costs, does that fall within the zone of reasonableness?
Sorry, $125 million?
I believe it's the customer benefits plan over 20 years, including the one-time refund. It's $124.7 million.
Well, first, I don't think I would include the one-time refund as part of that. If we look at the totality of Mr. Collins' proposal, he has about $70 million a year in merger savings, and for roughly 20 years, that's essentially the same as the upfront payment that Dominion proposed in their original proposal. So I consider that upfront payment to be a merger benefit, recognizing the savings from the merger, since Dominion does not have an ongoing merger benefits element. So I don't consider that payment to properly be deducted from NND costs. I think that's a merger savings. But even so, that $125 million, even if we take the $125 million a year, the experimental rate is, I think, about $75 or $76 million in that ballpark. So it's, what, 2/3 higher or thereabouts than the experimental rate. And again, I do not think that's reasonable. I always hesitate to talk about what's just or unjust, but I feel better talking about what's reasonable or unreasonable. And I think asking consumers to pay, $100 million or more annually for the next 20 years, and receive nothing for it, is unreasonable. As I mentioned in my summary, I think the total effect of Dominion's, or the NND portion of Dominion's proposal, would be to have customers paying about 3/4 of the cost of the NND project, and investors would pay about 10%. And I don't think that's a fair sharing or fair allocation of the costs of that project, especially given the fact that customers had no control over the project, but certainly utility investors did.
And did you review or conduct an analysis on the Dominion alternative plan?
I read it, but I did not do any analysis of it.
And I know that you said you just read it, but from your reading, do you believe that it would fall within the zone of reasonableness?
No, I don't think there's, in terms of the bottom line to customers, I don't think there's much difference between the two Dominion plans. There's a difference in the timing of when some of the payments are made, but that's about it.
And does SCNG's no merger benefits plan fall within the zone of reasonableness?
My answer would be the same for that as for the Dominion plan. The big difference between, or as I understand it, the big difference for the NND costs between the SCE&G plan and the Dominion plan is maybe $100 million over 20 years. Again, as I showed in my summary chart, it's the difference between about $5.6 billion and $5.7 billion in total payments from customers. So very little difference between the two, and again, a result that I consider to be unreasonable.
And Mr. Rubin, doesn't the utility savings from the Tax Cuts and Jobs Act just pass through to customers, and should it not affect cash flow or the entity cost recovery at all?
Well, that should be the case, and that's why I've focused on just looking at the nuclear project component of the different plans. The tax savings should be the same, more or less, regardless of the plan. The savings from the Tax Cut and Jobs Act should be the same regardless of the plan. And you're right, that is not a real cost to the utility. It just means they're collecting less from customers and paying less over to the federal government.
And one final question, Mr. Rubin. When the Commission is weighing the evidence and making its decision, do you believe that it should look to plans that fall within the zone of reasonableness and set the lowest possible rate which falls within that zone?
No, not necessarily. The reason we talk about a zone of reasonableness is to try to satisfy both consumer and investor concerns in as fair a way as you can, recognizing the uncertainty that is involved in all of these calculations. So while as when I put on my consumer representative hat, I like to see the rates be as low as possible. That doesn't always mean you go for the very bottom of the zone of reasonableness. There may be some result more in the middle that is a better balancing of the various interests involved.
Thank you, Mr. Rubin. That's it.
Thank you.
Thank you. Other cross from the parties.
Good morning, Mr. Rubin. My name's Rob Tyson. I represent the House of Representatives. How you doing?
I'm fine, thanks. How are you?
Mr. Bateman just asked, I've just got a couple of questions. Mr. Bateman just asked you about the experimental rate, and I just wanted to be clear on your testimony. You said you hadn't analyzed it, right?
I know what it is. I'm not sure what there is to analyze about it.
I was just repeating your testimony. I just want to be clear when you said that Mr. Bateman asked you whether it was within the zone of reasonableness, and you said you weren't sure, that you haven't analyzed it. And later you said you hadn't tried to verify it. So I'm just trying to understand your testimony.
No, sorry. I wasn't remembering the context there. I have not analyzed it in terms of a zone of reasonableness. I think I then went on and explained why I felt it was unreasonable to require consumers to pay anything more for a plant that will never provide them with service.
Well, that's why I guess what was my next question. I mean, none of these plans, the customers will not ever be able to get anything, correct?
That's correct.
That's what we're here for. It's an abandoned plant. So when you attack the experimental rate, That's true for any of the plans, correct?
Except for mine, yes.
Except for yours. That's right. Let me just show you. Sorry. This was a chart that was put up earlier, I believe, by Mr. Reed from Dominion, and it has a list of the different rates. Have you seen this chart?
Can you zoom out a little so I can see the whole thing?
That would take talent.
Oh.
We got talent on the way.
And believe me, I cannot help you with the technology. I have no clue.
All right, let's start with this chart. Have you seen this chart?
Yes, I have.
Okay, and on the far left is the SC and G rate, as it says, May of 17, correct? Far left bar, far left.
Yes.
And what was the rate there?
Which number are you asking?
I'm sorry. I'm focusing on the dollar amount per month. So the 147.53.
I see that, yes.
Okay, do you know what that number is?
Well, it says typical bill, so I'm assuming that's a typical residential bill. And that's what I was referring to when I said your bills are about the highest in the country for a typical residential customer.
Your bill's being SE&G's bill, right?
Correct.
Okay. And then let's go all the way to the far right. You see the ORS optimal plan, and you see the number right there. What is it?
That's $116.77.
Let's go over one to the left, and you see the H4375. You see that?
I do.
And that's what is that?
That's, I believe that's basically the experimental rate.
And I just want to understand your testimony. You're saying the difference in the $116.77 and the $125.34 is not within the zone of reasonableness?
Well, no. First, these numbers are not apples-to-apples comparisons. The existing bill does not include the savings from the Tax Cut and Jobs Act. So that's still being calculated at the old 34 roughly % federal income tax rate. The difference is being deferred, but it hasn't been reflected in customers' bills yet. And when you move to the other plans, that's a combination of amortizing the nuclear costs, in some cases reflecting some merger savings, and also reducing bills for the lower federal income tax rate. So we don't have really apples-to-apples comparisons here. As I understand it, the experimental rate is
the one that's listed right there. Is $1.25.34, right?
Right, and
the plan on the right is the ORS number.
Well, excuse me. What I don't know is whether the experimental rate number includes or excludes the tax savings. That's something I just don't know.
Okay, well, I guess the confusion that I was having when you said the rate, when Mr. Bateman asked you whether experimental rate was within the zone of reasonableness, I just wanted to understand, looking at the rate, and I appreciate that. It might not be 100% apples to apples or whatever, but these numbers are the ones that were presented on the chart. I just wanted you to be able to clarify to me and to the commission how that small percentage doesn't fall within the zone of reasonableness.
Well, a lot depends on, frankly, on what you're comparing to. What rate is reasonable when the federal income tax rate is 34% may be an unreasonable rate if the federal income tax rate drops to 21%. So that's why I'm saying I just don't know how all these numbers were prepared and which options are in them. Like, my understanding is that taking the nuclear costs on their own, the experimental rate is somewhat lower than the ORS optimal plan rate, but that's not the way it appears on this chart. I didn't prepare this chart. I don't know how those numbers came into being. So it's
No,
No, I
Sorry, I'm not trying to be difficult. I just don't know what went into all those
We're
numbers.
on our 8th day of this hearing, and we've been talking about what the different rates are. And Mr. Elliott and Mr. Knapp and others will stand up and they'll talk about what's the billing going to be to a customer. They want to know what's a customer going to pay. So they use this rate, whether it's apples to apples, whether it includes this or that. These are the numbers that we've been using.
Well,
So I just wanted to make sure that I understood a little better about why you believe the small difference in the ORS optimal plan and the experimental rate doesn't fall within the zone of reason.
Well, if I can address a couple of things you just said. First, I find it very unhelpful, at least to me, to be talking about the rate without understanding the components that go into it. And because those tax savings are a big number, and the merger or potential merger savings are a big number. And those serve to mask what's really happening with the nuclear project costs. And I do not consider it helpful to me, at least, as an analyst, to just put all that together and say, oh, look what will happen to your rate. Well, if none of the rest of this were happening, rates should have gone down in January because of the change in the federal tax law. And that's what happened in most states in the country. That didn't happen for SCE&G because all of this other stuff was happening. And I understand that. I'm involved in some other cases where the tax savings have been deferred because there was a rate case pending or a merger or something else was happening. But there's no question that, in the normal course of events, rates would have been reduced in January when the federal tax rates, lower federal tax rates became effective. So treating that as part of a package deal now, I find very unhelpful, and I would even argue is offensive because it's trying to take credit for something that customers should have been receiving 11 months ago. So that's the first part of my reaction to what you just said. The second part is I do not believe I said that I considered the ORS plan to be within the zone of reasonableness. As I said, for the nuclear costs, that would actually have more recovery from customers than the experimental rate would have. So I don't consider either of those results to be reasonable. I think customers have already paid enough or far more than enough to support a project that will never provide them with a benefit. The experimental rate certainly was a benefit compared to the full BLRA rate that was in effect before that. It was good to have that rate come down, but respectfully, I think it's time for that all to end.
Mr. Rubin, just the final question then. Let me just make sure I understand then. So if you were going to opine on what was in the zone of reasonable or what was a just and reasonable rate, you would need to look at a whole bunch of factors and a whole bunch of things, as you just said, and went through that, and you hadn't done some of that, correct?
That's correct. And normally when we set a just and reasonable rate, that's done in a full rate case where all of the utilities, costs, investments, rate of return, customer projections, sales projections, all of that is examined on a common base. That's what the test year is. So we put everything on equal footing and determine what the rate should be. We're not doing that here. We're making these piecemeal adjustments to the rate and hoping we come out with something that's just and reasonable at the end.
Thank you, Mr. Rubin. I appreciate your time.
Thank you.
Thank you, Mr. Tyson. Other cross from the parties. Company. While we're getting set up, I was just reminded we probably need to take about a 10-minute break right now, and then we'll come back to you, Mr. Willoughby, when we come back.
That will
10
be
minutes.
perfect, Mr. Chairman.